The amount of time it takes to structure a private equity transaction can make or break a deal. When the stakes are high and the time is short, private equity leaders turn to him to develop creative strategies to help them win auctions, mitigate risks, and close deals quickly. From groundbreaking monumental acquisitions to smaller strategic add on deals, he has implemented transactions with precision and care for established institutions, entrepreneurs, and emerging visionaries alike. Hello and welcome to An Hour with LawSikho, your daily dose of legal knowledge. I am Aditya, and the amazing individual I just spoke about is someone I am personally a fan of. Ladies and gentlemen, please allow me to introduce the man of the hour, Mr. Ashish Bhakta, who is the head of litigation, estate planning, and general corporate practice of A&B Legal Advocates and Solicitors. So we welcome you on An Hour with LawSikho.
Thank you so much. You're being very kind and saying whatever you have, but yeah, thanks so much.
Not at all, sir. It's everything that you are. Before we start with the whole show, we would like you to introduce and tell us a little bit about yourself to our viewers.
See, okay, fine. I have approximately 18 years post passing out experience with me. I passed out in the year 2000. I've worked in firms like JSA after that. I've worked in Kangan Company as a partner. And I worked for around 2 years abroad in London, heading the India desk over there. I had to come down for it's a very personal reason, and because that, from that time, I've started this law firm called A&B Legal. It's been 4.5 years now. We started off with just one colleague of mine called Rohini, which is just two of us, and now we are approximately 21 number. We got three partners now. We got four partners now, and we got offices in Bombay, Goa, Delhi, as well as in Houston. Now we just opened one in Houston. So yeah, that's about it.
That sounds really amazing. So I am really glad that you're a part of this show. Anyway, so sir, before we go ahead and discuss about private equity in detail, to start with, we would like to get a little context about what does one exactly mean by private equity in very colloquial terms for the students who have not studied about it at all.
See, private equity, generally people think of it to be only by way of equity. They just think that there will be an equity payout which will be made into a company and you will get some sort of a control over the company. Now, yes, it is for the control which any investor would put in any money into the company, because that's how he wants the company to run. That's how he wants to get his profits back. But private equity can have different ways of investing. It could be by way of debt, it can be by way of preference shares, it can be by way of debentures, any amount. So the structuring which comes into any deal, that's the main thing which goes into any private equity transaction.
All right. So the next question that I have for you is for people who are willing to get into private equity market. We read a report about a report by Investopedia, which stated that since 1970s, India has seen roughly 50%, 57% growth in the private equity market. What is the scope of private equity teams of a law firm in the near future, and why should a law student opt to go for something as new, as I would still call it new, as private equity?
See, for anybody to get into private equity, to answer your second question first, to get into private equity, you should understand numbers. You should understand the commercials. Law is something which will come to you at a later date. Right now, the first thing which you need to understand is what is going to be the IRR. What is the investment committee thinking when they're making a particular investment? What are the exit options? Why is a person investing? That's the main thing which you need to look at. And so if a student is inclined towards finance, is inclined towards something where he feels that he will understand the commercials, then I would think the best thing for him would be to get into a private equity transaction. Having said that, I would still feel that any student should first get into the litigation part of it, understand as to how disputes come into issue in such type of transactions, and it's only then that he gets into the actual documentation part, because students nowadays, have this big idea of me getting into private equity, etc., without actually understanding what it constitutes. That's one. To answer your first question, second, uh, India has been going up quite a lot in terms of private equity transactions. And as you know, recently, India being the only large company to go up in the ease of doing business index. So with the current government trying its best to push investments into India and out of India, it, I feel, has been fairly successful, and we lawyers are, of course, benefiting as a result of that. Yeah.
Definitely. So thank you so much for that answer. When we speak about, and it is very true that the law students right now do not have the practical knowledge that is required to get into private equity team. So if I am a law student and I'm looking at a job description of a private equity associate, what does that look like, and what are the everyday tasks of typical private equity team? How did it look like?
See, to be very honest with you, uh, it looks very rosy. For any student who wants to do a private equity deal, he goes through the years about Blackstone, years about Everstone, years about these big investment banking issues. He reads all this stuff from, he or she maybe, okay, will read the Wall Street Index, will see serials like Boston Legal, etc. They feel really excited to go in for that. But the ground reality is that you got to start, or any student who would, or any intern, or a first year student who would come in, would have to start from a due diligence perspective. Now, why is the due diligence so important, and why does a student have to start from a due diligence? Because that's the main part, where you start with a representation and where you start with a warranty. Then you actually need to see as to how good the business is, what is the risk the investor is getting into, what are the disclosures which are being made. Because, as you know, a misrepresentation has its effects under the Indian Contract Act, where one, you can sue for damages. Secondly, you can rescind the entire contract. So that's what I said even earlier. That if you know the litigation part of it, you will then be able to look at any due diligence not as just something which you have to do and you have to put into your data sheets, but you got to understand the business along with that. Once you understand as to why the investors are putting in so much money in a particular business, that it is only then which you will know how to go about it. And then you go to the next step, which would be the structuring. Then you go into the next step, which would be the actual documentation. Then you go into the next step, which you actually understand the clauses and how those clauses are worded in different scenarios at different times.
So the next question that I have is that to understand it very briefly, private equity is the last investment and the biggest amount of investment that's brought in a certain company at the last stage of the investment cycle. Now, how is this different? How is the private equity transaction different from a JV or a venture capital deal? How are the three different from each other?
See, a private equity transaction could be by way of a JV, or could be by way of a venture capital, right? So anybody investing would, of course, even if you're a joint venture, say when you're entering into a joint venture, it would be a private equity transaction. A venture capitalist would put in what you call as seed funding, or what is now very fashionably known as startups, would be putting the money into the startup. So that is also a private equity transaction. The difference would be that usually in a JV, there would be a special purpose vehicle which would be formed between the JV partners, which would then carry out the activities which both the partners have agreed upon. So that is the main, basically that would be the main difference. In terms of a venture capital would always look at what are the return to the investments which come in. Now, any venture capitalist would first be looking at the exit options as to if this particular venture does not work, because there's a high risk an element to it. So if this venture does not work, how do I get my money out? So that is the way both these things would be structured, especially in a JV. Okay, sorry, coming back to the JV, the most important clause which you look at is a deadlock provision, where you know that that both the partners are 50% partners, both the partners have certain affirmative vote rights. If the partners do not agree to that particular investment or to a particular mode of carrying on business, what do? There would be a deadlock. So how do you work out the deadlock provisions would be the difference between the two.
I think that is very well put. Thank you so much for that answer. For everybody who's watching us right now, we are 10 minutes down the show. We are open to questions right now. You can post your queries in the comment section or the chat option, whatever is feasible for you. Or you can personally WhatsApp me on 961-891-0356. I repeat, you can personally text me on 961-891-0356. So when we talk about, you just distinguished the three, PE, JV, and VC. If we look at the structuring of a PE fund, how is that structuring done? What is the structure of a PE fund in totality?
See, a PE fund comes in various forms, in the sense that it can be a if, right? It can be one of the if funds which is actually registered with the SEBI. Now, an if fund it can be in three forms. It can be either by way of a trust, it can be by way of a LLP, or it can be by way of a company. Now, in my experience, or maybe my limited experience, I've never seen a if fund which has been by way of a company or an LLP. Most of them are by way of a trust. Now, why does a trust work for them is because of various issues as regards taxation, as regards registration, as regards the functioning of that particular entity. So that's how usually the entities would be.
All right. When we were talking about the structuring of PE firms, now within what time does a fund have to provide returns to its investors?
Within what time the fund has, see, usually funds are always say they have a period of 3 to 5 years, whether it be a startup, whether it be a fund which is invest sorry say whether it be a fund which is investing in a startup, or whether it be a fund which is investing in an actual running company. Now with that, there is always basically which usually, okay, it's not something fixed, but an equity return would be, say, somewhere in the region of 25%. If it's a debt, so the return would be around 16%. If it's a hybrid, you look at a return of around a 21%. So that's how much the returns are expected to be, or that's how much a particular threshold would be for any private equity fund to get from the particular investment.
Sure, but this is the amount of investment that a person can probably expect out of the private equity transaction. My question to you is that what is the time period in which the returns can be expected out of certain investment that you're making by the way of private equity?
See, See, that's what I said. That the investments return is usually a time period between 3 to 5 years. You cannot expect the money to come in the first year or in the second year. It and plus it all depends on the kind of investment which you made into a particular entity. Like, say, for example, if you are investing into say a infrastructure company. Okay, say the infrastructure company will not give you returns till the time the actual, like, say, for example, it's a road, right? Now, when you're putting in money in that particular project, till the time the road is not made, till the time the cars don't pass, till the time you can't collect the toll, there is no way which you're going to get the money back. So it all depends on what kind of investment you're making. But as I told you earlier, the threshold period would be around 3 to 5 years, and as I said, equity 25, debt 16, and for a hybrid it would be around 21.
Thank you. Thank you so much for clarifying it out, sir. So when we talk about all of this, so who are these investors? Who are the typical institutions or investors who contribute to the fund? And let's say if there is an investor, then what is an actual life cycle? Or can you please explain the life cycle of a private equity fund?
Life cycle of a private equity fund. No, see, as you know, there are two kinds of investors. Okay, one who is the LGs, yeah, who are the and the other would be the um, uh, one would be LGs and the other would be the fund managers, right? So sorry, and they are called the GPs. So they are called the general partners. Now the general partners are the funds, whereas the LGs are the ones who are the actual investors, right? So there is a difference between the two. Investors, in a sense, they can be individuals, they can be partners, they can be a company who is just getting into investment, right? So that's one. I'm sorry, I didn't get your question as regards what exactly do you mean by a life cycle
Yes.
of the fund.
Can you please tell us as to what is the entire process of a private equity transaction? If you
Okay,
could
a
just help.
transaction. Okay. Sorry, I got confused. I thought maybe you're asking me for a fund, which is something completely different. So, a private equity transaction first of all starts with expression of interest, right? Where an investor would look into a particular entity and say that, listen, I may get a return out of this particular company. Now, if I'm getting a return out of this particular company, I will want the company to accept my proposal to invest into that company. Now, for doing that, the first thing which they do is that they enter into a term sheet, right? The term sheet would actually specify the company, it would specify the kind of investment, it would specify as to what are the roles and responsibilities of the promoters of that particular company and what exactly is the investor looking into. Usually, the term sheets are non-binding, right? And the term sheets would also have a time-bound this thing that once that within, say for example, say for 3 months, if this deal does not go through, then the term sheet is deemed not entered into or it's supposed to be expired, right? So but what happens within those 3 months? Within those 3 months there would be a due diligence, there would be other negotiations as regards to definitive agreements, etc. There would be post closing, pre-closing requirements which you need to enter into, and it's only then when the entire transaction gets over.
Thank you, sir. So the next question is that what is the governing or the constitutional document of a private equity firm?
So see, there are a lot of documents which are known as the definitive documents, right? So once the term sheet is entered into, the term sheet specifies that the term sheet will end when you enter into the definitive agreements. Now what are those definitive agreements? There will be a shareholders agreement, there'll be a share purchase agreement, but those two are not the only agreements which you enter into. Like say for example, many a times uh, an investor is entering into an investment in a particular company because he knows that there is this key employee who is there. He's a CEO of that particular company. He's run that company for the last 3 or 4 years, and without him, I cannot expect the returns which I'm even thinking of. Right. So he would want to enter into an employment agreement or a retainer or a consultancy agreement with that particular person to state that till that till the expiry of 5 years, you will not be able to leave this particular company, or you undertake to be in this company for that much time. Now, all these main documents or the definitive documents are then entered into your articles of association of a company, because any inter se shareholder rights, if they're not entered into the articles, will not have any enforceability. So if you're asking me one document which is the most important document, yes, I would say that would be the articles, because that's where all the documents would be summarized and put into.
So if I get it right, there will be a shareholders and a share purchase agreement, and a couple of other agreements, let's just say, which will bring an effect to the articles of association, and that's when the deal is final and binding.
Right.
All right, great. So let's continue with the next set of questions, which is that how does a fund manager in a private equity fund earns? Is it a function of assets under the management plus returns, or how are the fund's earnings regulated if they're regulated at all?
See, uh, honestly, I'm not aware of any regulations, but I can tell, and I don't think there are any. But To answer your question, it is what is known as a 220 model. Very no, it is very popularly known as a 220 model, where 2% would be the management fee. That is something which they would take upfront, right? However, 20% is something which would be over a 3 or 4 year period, as I just mentioned earlier, where 20% would be the returns a fund would get based on the return which the company is making. Like, say for example, if a company is making 100 rupees year on year for 5 years, then 20% of that would be the fees of the fund manager. Now, there is always also a threshold limit which is there. That if the company exceeds that threshold limit, or the company earns more than what is expected because of the investment being done, then the P so then the fund would earn that much more than what is originally stipulated. But to come back to your question and answer in a nutshell, it's very popularly known as a 220 model.
All right. So, I really want to know if this fund manager is a function of assets under management plus returns.
Yes, it would not be on management and returns. It would be basically, see, the management fee is taken upfront. That is something which as and when as a fund invests into a company, that 2% of whatever is the deal size would be taken upfront. However, it's something like a, you know not exactly that, but something like a brokerage fee, where you're getting your money upfront, right? However, so the 20 would be return on your investment as to how much the company is making profits, and because of those profits, that particular investor is making that much money, and that's how the PE fund would get a percentage of that. Now that is called something as a uh, as a carry out method, but which is actually there for the P. If you go to see for hedge funds, it's called the catch up method, depending on what amount the particular hedge fund is made. So it all depends on what on what kind of fund it is and what is the model. But again, to repeat, it's a 220 model. 20% of the returns per annum or on the investment, and 2% would be a upfront fee.
All right. So before we go further, we have a question from somebody called Rajiv Kulkarni, who wants to
Yeah.
know that private equity open-ended or close-ended?
See, a private equity is usually a open-ended scheme. It is not something which will be closed-ended. However, it depends on the kind of fund as and when it's set up, right? It all depends on the time when those uh, when those fund managers, they get together, and they give out the PPM, which is known as the private placement memorandum. Everything would be mentioned in the private placement memorandum, but usually they are open ended.
All right. We'll move to the next section of the show, wherein we are going to talk about the various types of transactions executed by PE firms in acquisition finance. The very first question that I have is that is the Vishal Megamart investment by TPG and Shriram Capital in 2010 an example of a private equity buyout of a promoter-driven company? And if yes, then do we have more such examples in India?
No, there have been a lot more examples. There have been examples going on since I think years now, and it's not only a particular sector. They, like, basically in various sectors this is happening. Like, say for example, say in the energy sector, Punch Lloyd was taken over by, I believe, IDFC, I believe. I'm not very sure, but I know for a fact that Comstar was taken. Comstar was an auto company which was taken over by Blackstone. Modern Bakery, which was the FFCG, was taken over by Everstone. So there are a lot of examples which are there in that space.
Okay. So the next question that I have from you is I'm like flooded with the set of questions right now. But I'm going to take a question by Mr. Kunal Chandriani. His question is that usually a private equity funding for startups are assisted by chartered accountants and investment bankers. How can a lawyer gain edge to gain more deals?
See, a lawyer doesn't need to get into any edge or anything like that. The thing is that, as we say, the person who's supposed to do the work should be doing the work. Like, say for example, if an investor comes to me and tells me that, listen, I am going to start this startup, right? Please help me with the taxation issues, or please help me as to how do I manage to get a particular IRR out of this company. I will I I may be able to help him, but I won't be able to help him as well as a CA would, right? So it is not about getting any edge or anything like that. It's all about doing what you are supposed to do, or what you can do. So if you know that you can do a particular drafting in a particular manner, okay, there's no need for you to get any edge over anybody. I don't think that. And see, in the end, we all are professionals. We all are looking towards a common goal to make sure that our client or whoever's come to us gets the best out of us and the best out of the deal. So I don't think that there's any issue of any edge, very, very honestly.
Sure, sir. So, sir, the next question that I have for you is from somebody called as Shweta Tiwari. Her question is that is there an NBFC structure also that funds used to invest?
I'm sorry, I didn't get the question. Could you please repeat
The
that?
question is
NBF.
that is there an NBFC structure also that funds used to invest?
See, a NBFC invests in other companies, yes, but a NBFC structure to invest, I didn't get that question honestly. Very honestly, I didn't get the question because see, NBFCs are of course used to invest in other companies. Like, say for example, if there's a leverage buyout, if there's a mezzanine financing, it can be done by way of an NBFC. But other than that, I'm sorry, I didn't get that.
All right, Shweta, if you're watching us right now, we would want a small clarification on it. Please do text me ASAP. We'll move ahead with the set of questions that we have for you. The next question that I have for you is that now that we're talking about obtaining finances, how does a private equity firm obtain acquisition finance? What are the sources from which acquisition finance can be obtained, and are there any statutory rules and regulations governing such finances?
No, in the sense of private equity fund, you're talking about a private equity fund getting the finances, right?
Yes, a private equity firm
Yeah,
getting finance.
yeah. See, so private equity fund cannot have finances coming in from individuals. It would always be done by way of a PPM, by way of a private placement memorandum, where where they call in for the investments based on that PPM, and that's how the fund would get its money. Now there are various kind of funds which it can be an onshore fund, it can be an offshore fund. Uh, Usually the funds which come in are usually coming in through either Mauritius or Netherlands or Singapore, or various places. So it depends from where the money is coming in that particular fund.
All right. Okay, I get your point there. So you were just talking about mezzanine financing.
Right.
What is the meaning of it? What does mezzanine financing mean in the first place, and when is it used by private equity firms?
Private equity firms very rarely use a a mezzanine financing. It is that an investment is made both by way of equity and by way of a debt. Yeah, it's only in case of default of that particular investment which is made, that is when the investor would get a right to convert his debt into equity and to get his funds back. So that's how it's done, but it's very rarely done because in the waterfall of the debts coming due back to the investor, it's at the back. Secondly, every PE investor or a PE fund looks at how well you've done in terms of your investment. Mezzanine financing is, if I can say a little, it's a back step or a step which you feel you may not be able to succeed, and that's the reason why you go in for mezzanine financing. So usually private equity funds do not go in for a say for such kind of financing.
So when is it exactly then the firms are, let me say, compelled to go for mezzanine financing?
The firms would go in for mezzanine financing only when they feel that this particular entity requires that particular amount, and we may get a particular return out of this company if a particular manner in which this company is run continues or is discontinued. But if that goes off, then it's issue. And usually mezzanine financing is done for companies which are already in trouble, if I can call it that. Yeah. So that's
All
how.
right. So in stages of distress, maybe that's when the companies go
Yes,
for
exactly.
mezzanine. Got it.
Yes.
All right. So the next question that I have is that I when I was researching for this topic, I came across a term called bridge finance. What
Right.
is bridge finance? And again, the question remains the same: that when do private equity firms or companies need to obtain a bridge finance?
See, just to put it very simply, and I'm sure because a lot of students over here would be listening, uh, a bridge finance is basically assisting you to get over a particular area or a particular time period where you are in trouble. Right now, why would a PE fund go in for bridge financing, or why would any entity which knows that yes, I have a particular amount of investment coming in to my company, go in for bridge financing? The reason why usually companies go in for bridge financing is that that what I mentioned earlier, the time of the threshold, or the time of from when a company makes profit, it starts from or the clock would start ticking from the time when the private equity fund transfers that amount into that particular entity. Right? That's a time when the clock starts. However, you when the fund manager knows that this particular company needs this particular finance for this time or for this particular purpose, it would be better to bridge finance this particular debt, get get over with that debt, and then the company can start its profit. When you do that, that's the time when the company or a fund usually goes in for a bridge financing.
So can we say that to get rid of a pre-existing debt, you were getting into a new
It's
one?
not only for a debt. It's not only for a debt, Aditya. It can also be to tide over some sort of a difficulty, like in the sense that that say for example, uh, that a particular machinery is required to manufacture a particular product. Right now, till the time the machine comes in, it has to be exported. You need to pay your duty, have it affixed. You have to say start a trial run or whatever you need to. Till the time that is done, you know that you can't move out the product. Say you can't fish out the product. If you can't fish out the product, your profits won't start till that time. So it's better that you go in for bridge financing, where you know that you can get that particular machine or whatever it is fixed. And once the product is ready to roll, that's the time you do in the private equity investment. The private equity funds that much more leverage to say that yes, I put in the money from this much time, and this company started making profits from
I'm sorry, Mr. Bhakta, we are losing you a little. I think there's a problem with the internet connection. Can you hear me?
Can you hear me? Yeah, yeah.
Yes, we lost
Would
you
you
a
want me to
little.
repeat?
Yes,
Yeah,
yes. If you could
yeah,
just
yeah.
repeat the last three
Yeah,
sentences.
see, in a nutshell, it is not only that the bridge financing is done to clear a particular debt. It can also be to make sure that a particular asset is up and running, so that once the private equity fund manager puts in the money, uh, the profits can start as soon as possible. Once the profits start as soon as possible, that's where the fund manager would be earning from. So that's in a nutshell.
All right, sir. Thank you so much for that explanation. Now, The next thing that I want to know is that does Indian law permit leveraged acquisitions? To what extent can you use the debt, and from which categories of institution for the purpose of an acquisition?
See, of course, it permits a leverage buyout. The most famous, it's the most it's the most famous buyout is as regards Terry, when Tata took up that say your tea brand, your Tata Tele brand. Right? A leverage buyout is usually when you know that this particular entity may give you X amount of profit again. However, you want to make sure to say that if it doesn't, I know that I will get my return out of that particular investment. Now, now there can be various kind of uh, instruments which are used. It's not only your debentures, but it could also be your convertible preference shares, where you know that I would get a preference over the dividends which are uh, which are going to be passed, or which are going to be issued by the company from time to time. I will get, say for example, 8% over and above the dividends which are coming to me, or I'll get a fixed return of say 12% till the time the company is up and running. Once I know that the company is up and running, have that preference share or debenture or whatever I've chosen to invest in, depending on my kind of investment, convert it and become an equity shareholder, and then have whatever rights I have as an equity shareholder.
All right, sir. Okay, so let's talk about this particular case, which although is disputed, however, I'll still bring it up that in case of Tata's acquisition of Bhushan Steel, 50% of the acquisition amount, that is roughly 16,500 crores, was financed out through debt. But it was mentioned that the debt will be moved to the books of the target company after acquisition. Now, the question to you remains that okay, if this is the case, then how does an acquirer legally move debt obtained for the purpose of acquisition onto the books of the target company in practical application of it? And what kind of documentation is executed for that purpose? And what does it have to say? Now, the question is also that if there can be more examples, because this is a disputed case, it can be there can be more examples of such transactions, and what is the process of doing it, and what kind of documentation is required for it? That will be great.
See, in case of Bhushan and Tata Steel, it was done by way of the NCLT, right? So 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 in case of documentation, it would all require the order of the court. Now that would be a main documentation which would come into place. Now, if you're asking me for similar examples, the similar example would be Binani Cement and Ultratech, right? Where Binani Cement was bid for a particular amount by the Dalmias, and the Ultratech said that no, I would want to bid in for this huge, for a much bigger amount, right? What I said is that the date on which you needed to bid had already expired. Once the date has already expired, even if a bigger amount is coming in, there is no way on which you want this bid to go through. However, everything is determined in these issues, especially in the NCLT, by the COC, which is a committee of creditors. So any committee of creditor would always want a larger chunk or a larger amount coming in into its kitty, to make sure that they get whatever is due to them, right? So of course, all this is right now with the NCALT and with the Supreme Court and with various courts right now. But to answer your question, all this would be determined by the institution, or would be determined by the court or the tribunal, which comes in, and the documentation would be done through them.
All right, but any if we were to talk about that, there's a set of documents that the NCLT might prescribe. However, is there like a standard, is certain standard documents that are required for this kind of a transaction? If you would throw some light on that.
No, there would be. See, trust me, in a private equity transaction, there's nothing standard. There wouldn't be anything standard at all. You need to make sure that it is drafted depending on the facts and circumstances of the case. As a law student, especially, you should know that everything hinges on these words. It depends. Everything depends.
All right, sir. We will talk about private equity. And yesterday we had a session with Abhyuday Agarwal on a shareholders agreement. Now,
Okay.
so I believe that this is more or less an extension of it. So let us try to understand, and please help us understand that how is a private equity a shareholders agreement look different from an angel investment or a VC investment shareholders agreement.
As I mentioned to you earlier, at the very start, that a venture capital shareholders agreement would always be a little wary, if I can call it that. They would always want to make sure that the returns are coming in. If the returns are not coming in, they have various exit options which are built in that. It can be it can be a put option, it can be a call option, it can be by a buyback, it can be by 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 whatever means they deem fit, but basically to get their returns out. Also, the other part about a venture capital shareholders agreement would be that the funding would be in tranches. It's not necessary that I've given you the money right now and that's the end of it. No, that's not how it's going to work. There might be a stage where you might require a further round of funding. And when that further round of funding happens, what would be the rights of the shareholders who would be coming in? What would be the rights of the promoters? What would be the rights of the people who already invested in the company? So it again, it all depends on that.
All right. So now that we are talking about it, how is the interest of a private equity firm and multiple prior VC investors in a shareholders agreement managed together? Because I understand that all of them will have different intentions. So, if you can mention specifically with respect to the following subtopics that I would probably mention. The first one that we want to know about is affirmative voting rights.
See, affirmative voting rights is something which no investor who's already invested in a particular entity would give up so easily, right? He would want certain affirmative rights to be there, but affirmative rights also depend on the kind of investment which is coming in, or the leverage, if I can call it that, not to be confused with the leverage which we mentioned earlier, which is coming in right now. So, for example, an investor who's coming in at a later date is coming in not only with bag full of money, but it's coming with a lot of IP rights, or it's coming with a lot of know-how, or it's coming with a manner in which a particular business can be taken in different spheres. That's how you would that's how you would determine as to what affirmative rights would be there, and what would be the affirmative rights of the present investor, as well as what would be the affirmative rights of the investor who's coming in.
And what about board representation?
The board representation also would depend on that. See, once you have your affirmative vote rights, it depends on the board, right? It depends because it's a board of directors who are going to vote based on those affirmative vote rights. So it may depend that in case again, like, so whatever I mentioned earlier would automatically apply to their board rights.
All right. And yesterday, Abhyuday told us something about tag along rights and drag along rights. Are
Yeah.
these rights as well? How would be they How would they be managed?
See, a tag along right or a drag along right would depend on when the particular investor wants to exit, or what is the idea of a particular investor as to what he thinks it's a threshold of his investment. If he so it again it depends on the kind of it depends on the kind of investor coming in. If the investor thinks that this is my threshold limit, I will sell off this company at at this particular stage, or I will sell off my stake in this particular company at this stage. I would want you to drag along with me, yeah, or to make sure that I get the full right of the investment.
Okay. So we'll talk about the next set of rights, which is the right to first offer, right of first offer.
Yeah, see, there are two things. There's not only the right of first offer, there's also right of first refusal. Right? So there are
Yes.
these two different things. Now, usually the investor would always go in for a right of first offer. And why is that? That is because they get a right to determine what the price is. In the sense that I'm giving you this offer, would you want to take it? Person says, no, I don't want to take it. Thereafter, I've determined a price. I've put a threshold for that particular price which is there. A right of first refusal would be that, fine, if you want, you can refuse that, but then I can go in for somebody else. Now in that, I won't be able to determine the price threshold for that particular investment.
Okay, and what about liquidation preferences?
See, liquidation preference rights is something which you need to keep in a very, in a very careful manner. There are two methods which come in for a liquidation preference. So both these methods are slightly complicated, and it may take some time for me to explain to you. But having those, but any liquidation preference which comes in, you need to make sure that your right is not diluted. So what is a liquidation preference in effect? In effect, the liquidation preference is that in case there is more subscription of shares are subscribed to any investor coming in, I will remain at the same percentage which is there with me today, and I will not dilute my preference. Right? So my liquidation will remain the same. Now that again will be on the kind of investment which is coming in, or the stage at which the company is. If the company is looking for expansion, then you got an upper hand to say that, listen, my liquidation preference will be as it is. But if the company is under stress and you know that you need that investment to survive, then then there will be a different manner in which you put in a liquidation preference.
So, in the same context, would you like to talk about any other clauses which are relevant for this particular issue so that we can move to the next set of topics that we have?
See, in terms of an investor coming in, what the other so the other important part would be your ESOPs, because every company, as you know, it can be you, it can be me, it can be anybody, runs through its employees, right? So any investor who comes in wants to give that incentive to a particular employee to continue and to be a part of that particular company. Now, when the ESOPs are to be converted, right? It's a right for you to convert to equity shares. So when is the right for you to convert to the equity shares, and then depending on that, uh, how an investor is going to take your being not only employee in that company but also stakeholder will be of relevance. So ESOP is something which is really important, other than whatever clauses which you very rightly mentioned.
All right. So, when we're talking about private equity, it is inevitable to talk about pipes transactions. What are pipes transactions and how are they different from ordinary private equity transactions?
See, pipe transactions is a private investment in a public entity. That's pipe, right? So that so uh, when say for example you got a huge amount of shares in a particular entity, in an entity which is a public entity, right? And you want to sell them. Like say for example you got 5% stake in a company like Ultratech. Now, if you want to sell that 5% stake in a company like Ultratech, you're not going to be able to do it right away, right? No, it may be that one, you may not get the value which you think is there. Secondly, it can also be that the market will not have the particular appetite to buy these many shares. So pipe transaction usually is done by way of by way of a buyout between two brokers, in the sense that brokers or whatever the investors, or whatever you call them, to say that I want to sell these many shares of this particular entity. This entity wants to buy these shares. Let's do it sitting across the table. Now, in these kind of in a private equity transaction, say we just spoke right about drag along rights, affirmative vote rights, board representations, etc. Nothing of these sorts can be expected out of a private entity. Oh, sorry, out of a public entity, because a public entity is not going to give you those rights just because you own some 5% shares or 4% shares.
All right. In such a scenario, if I understand it right, the articles of association of public listed company cannot have special rights in favor of any shareholder. So, how do these private equity investors ensure that their interests are safeguarded in a PIPES transaction?
See, in again, in terms of a pipe transaction, there cannot be any clause which you can enter into, as you rightly said, in a company. So what they do is that they try and leverage it out. They would have a certain amount of debt in that particular company to make sure that if I need to if I need to affirm my rights, if I need to move something which I feel is going against me, I would do it by way of a debt, because by way of equity, I don't have the same power which I have being a private equity fund or being an investor.
All right. So help me understand this better. That how can a PE investor take a company private post a buyout, or can he do that? And does this happen in India?
Sorry. Say that again. Say that again.
So how can a private equity investor take a company private post a buyout? And can this happen in India, or does this happen in India?
This does happen in India, and make a company private, in the sense that there are many methods to do that. You can do it by way of a reverse merger. You can do it by way of delisting. There are various ways in which you can get a particular entity to become private. But in my experience, I've not seen that many happening of late.
All right. But from your past, if it would be really nice if you could give us an example of when it has happened in the past.
I don't recollect that right now as such. Maybe I'll just send it to you later, I guess. I'm sorry,
Sure.
I don't recollect. Okay. Yeah.
That is absolutely okay, sir. So, sir, now that we've spoken so much about private equity, I have a couple of questions from you from our viewers.
Yeah.
The first question that we have is that from again, this is a question from Kunal Chandriani. His question is, which laws, acts, and rules are required to be studied thoroughly for one who desires to enter into private equity?
Thoroughly, my God. Trust me, you need to know all the acts, whatever acts are possible. Because, but apart from that, of course, need to know your Companies Act. You need to know your FEMA regulations. You need to know FDI. You you and more so, you need to understand how a particular industry works. In the sense that if it is an automobile industry, you need to understand what are the pros and cons of running a particular of running an automobile industry. Why? I'll tell you that. If you're investing in a in a an automobile company, say for example, you are doing a due diligence, yeah, as we just discussed initially, that you go in for a due diligence first. How would you know whether a particular entity has complied with all the provisions which is supposed to comply with? And you will not be slapped tomorrow with a big fine coming in from any regulator to say that you've not done the XYZ, or you don't have XYZ license, right? So you need to understand that really well. If you know that well, that's great. And trust me, you don't need to know laws as much as of course you need to know the laws. It's not that you don't need to know the laws, but more so you need to understand the commercials. Once you understand the commercials, you'll be able to draft it out as well as possible, because in the end what you're writing down is English, plain simple English language, depending on the commercials between the parties.
All right, we have a question for that as well. Actually, you spoke about one should understand the commercials. So, when you mentioned that having numerical or financial knowledge is important to get into the field, which financial concepts do one need to have a clear view regarding private equity?
Of course, it'll be your IRR. Yeah, it'll be your internal rate of return. How do you calculate that internal rate of return? It would be also as to how you make sure that your liquidity preference remains whatever it's supposed to be. You should also understand how EBITDA works. Yeah, which is your which is most important. Apart from that, you also have to understand numbers in the sense that how are you going to make sure that this investment which is going in by a fund or an investor is going to be returned when you exit this particular company. So all these need to be assessed, and it's not only that. You also need to understand the taxation part of it. It can't be that you're exiting a particular company and you're slapped with a huge tax demand from your tax authorities. So yeah.
All right. The next question that we have for you is that can you please throw some light on the internship paths a law student should take for one's aspiring to enter into private equity laws? What are the points one should follow?
I would say if anybody wants to get into a private equity internship, unfortunately that doesn't happen right now because the interns come in for 1 month, 2 months. The intern should try to be a part of the deal right from when the term sheet is being entered into, right till the definitive agreements are entered into, and not only because entering into a definitive agreement is not the end of the transaction. There'll be certain post-closing requirements also. Closing is, of course, the time when sorry, you said something? Yeah.
No, no, no. Please go.
Closing is a time when the money will get into the particular entity, right? But once the money gets into the entity, there are various other things also which need to be complied with. Say, for example, a license which is getting expired, you need to renew the license, or you need to make sure that the license is renewed. There'll be various things like that. So if during the internship you can see one full process, yeah, that'll be the best thing for you to do.
All right. So for the next question, I'll have to give you a bit of context. This question is coming from Mr. Venkat, who is a diploma in entrepreneurship and business
I'm
law
sorry.
student. Can
I'm
you hear
sorry.
me?
Yeah. I can hear you
Uh,
now. I couldn't hear you earlier. Yeah.
okay. So the next question, I'll have to give you a bit of context. The next question is from Venkat, who's a diploma in entrepreneurship and business law student. Uh, from LawSikho, we are running a couple of courses. One of them is a diploma course on entrepreneurship and business laws, and this is a very descriptive course on various aspects related to business laws, private equity being one of them. His question is that I have an 18 plus years management experience in shipping, port sector in India and international with finance operations knowledge. With the DA, with a diploma in entrepreneurship and business law certificate, what could be the scope for him to join a law firm's private equity team?
I would think the scope would be awesome because it's not only as regards ports, but ports now are going the digital way. In the sense, the earlier times, you would have your bill of lading, you would have various documents which a CNF agent would have to enter into, right? But if you got a shipping experience now, all this is getting completely digitalized. So there are companies like Odex, which are the pioneers in this field. And apart from that, there are various other firms who actually do the work as regards ports. Start from the non-negotiable conditions, from the tenders coming in, from what we call the concession agreements being entered into. So there are various. It's I would think it's a great scope of work for him to do.
All right, that's all for today. So, any closing thoughts that you have right now?
No, I don't have any closing thoughts. If there are any questions, I'll be happy to answer them. And thank you so much for having me over here. It was a great time that I had, and of course, I can't see the audience, but I hope that they had a good time too, and they understood what I had to say. Yeah.
All right. Thank you so much, sir. It was an absolute pleasure and delight to have you on this show. For everybody who's watching us right now, that's it from today, from us. Thank you for watching An Hour With LawSikho. This is me, Aditya, signing off for today. Don't forget to like, share, and subscribe. Do hit the bell icon as we are going live every Monday to Friday from 8 to 9, only on this show called An Hour With LawSikho. See you tomorrow with yet another expert who's going to talk about some aspect of law that you don't know about. Thank you so much. Have a great night ahead. Have a great night ahead. Bye bye.